Thank you, President. Thank you, Sergio, and the organizers for the wonderful organization and the wonderful town you arranged the meeting in. Yeah, I'm going to present a current project coordinated by us on comparative tenancy law and black rental contracts in Europe. Yeah. And our inspiration is the following. Normally, lawyers or comparative lawyers tend to be bothered about the classic areas of private law, which are heavily technically influenced and which change very little over time, such as the basics of contract and tort and so. And adapting a well-known German saying that by a literature critic, one could say that he said actually that novelists know as much about literature as birds do about ornithology. And you might adapt it to comparative lawyers by saying that comparative lawyers know as much about comparative tendencies as birds do about ornithology. But I haven't checked this saying, and I haven't contacted any birds about it. Maybe you should verify with them. So this is the inspiration to get into a field which has a strong social and economic and political embeddedness, so which makes comparative law even more interesting. But the background, our background and all background of all the members of the consortium, which you see here neatly listed, is law. We are all lawyers, but try to integrate the context of the law, which is called law in context, or not context without law, but law in context. You see, we have 10 teams, and we are intend to cover 31 European countries, or European, even more than that, 27 EU countries plus 4 other countries, and Scotland, Scotland. Of course, still, hopefully always part of the EU, but it has got another legal system, Switzerland, Croatia, and Serbia. Croatia had at the time of the proposal, the membership was not entirely clear, but we had already taken it on board. Also Serbia, and we have further voluntary participants who, happily enough, wish to contribute to the project voluntarily. Okay, so this is what we sent to the European Commission to give the whole, professional flavor. What would you have been supposed to do when, if everything had gone well? So this is the implementation table. Okay, and our objectives are following. In the first step, we analyze national legislation context, then we analyze the effects of EU law on that legislation, then compare, and then try to determine a possible future role for the EU in tenancy law, if such a role is desirable at all, which is not taken as granted, of course. So in somewhat more detail, the first step, the analysis. Current situation of national tenancy law, which is of course hugely changing, particularly in these days due to the crisis, and also we try to pay heed to tenancy law's embeddedness in a variety of housing policy and the national or even regional markets. We try to take into account a procedure, so not only its existence in the books, but how it's actually handled if there are ever court suits, because we've heard that in many states it's very rarely. I mean, it goes before courts, and there are certainly reasons for that. So, and we, of course, analyze the core fields of private tenancy legislation, such as conclusion of the contract, duration, rent fixing, rent increase, and ancillary obligations of the parties. Then the second step would be an analysis of the effects of EU law and policies on national tenancy law. as you know, the EU has absolutely no concept on tenancy law. But what happens is that there are sort of what you call in warfare collateral damages. Yeah? Collateral damages exercised by other EU policies and other EU rules on tenancy law. So and no one has ever thought, in many cases, no one has ever thought really in a profound way about these collateral effects, you have to call them in a more neutral way. And they are derived from social policy, consumer law, but even other matters such as private international law, tax law, energy rules, some growing impact of constitutional law and the European Convention of Human Rights, and even the most recent endeavors towards a common European sales law might have some impact on tenancy law, in that this regulation or proposal for regulation contains general rules, general contract law rules, which are potentially capable of being extended to parts of tenancy law at a later stage. This has been completely overlooked so far, that we might get general contract law rules, which in many countries have the role of regulating parts of tenancy law. Okay, the objectives, intra-team and a consortium-wide comparison, of course. And our, say, working hypothesis is that of a socio-economic balance, which we claim that should be respected by national regulation, so socio-economic balance between the position of both parties. Of course, this is still a quite wholesale point of departure, but it's perhaps better than nothing. Yeah. So the objectives, what is the future role for the EU in tenancy law? Of course, we want to unify and harmonize everything despite the financial crisis. No, not at all. No, not at all. We want to take stock of what is happening, no? And some things are particularly relevant. So we exclude full harmonization and even minimum harmonization, even if theoretically it might be possible under European consumer law, if you subsume tenancy law under the heading of consumer law, which can be done. I mean, then there might even be a legal basis, but no one has ever thought to use it even in consumer law. It's rarely been used, but tenancy law not at all. But the social dialogue which exists in fields of social policy might potentially be one day extended to tenancy regulation for the future. But what we are about to do is extend this so-called open method of coordination to tenancy law. Yeah? And this consists, as you may know, of best practices, mutual learning, peer review, and so on. And this technique is applied in fields where the EU doesn't have any legislative competence. So it comes actually very close to what Maria said yesterday. You know, we want to simply learn from each other, evaluate failures of different national housing systems, but also their bright sides, and then come up with proposals of mutual learning. This would be our ideal goal. And now, I'm going to present in the remainder of the presentation some very provisional findings, because the project has been going on only since 1 year, and we're still in the phase of fact-finding, of retrieving the applicable national rules and so on. So we have listed from the national reports from these 30 countries, which we have received so far, a list of failures, of problems, of main problems. And there are plenty of them. And of course, we won't be able to tackle them all, so we won't be able, of course, to render the European Housing Research Network superfluous, as you may imagine, yeah. But what we want to do is to tackle those problems which have, a huge legal dimension, so where lawyers can actually be useful. That's our idea. So I think overcrowding and housing poverty is, at least as far as private lawyers, as we are concerned, can, I think, be influenced relatively little by private law rules. But other areas can be influenced much more by private law rules. And of course, this is the whole chapter of rent regulation, but also discrimination in access to housing, and then adverse economic and social phenomena directly related to bad tenancy regulation, such as the notorious phenomenon of landlords preferring to leave dwellings vacant because of strict rent regulation, which you may find in many European countries, that they say it's not worth it, I don't get a tenant out when I need the house for myself, so I prefer not to rent it out in the first place, which is of course very sad, I would say, for the whole situation. What we also have in many European countries are unjust intertemporal splittings among different tenancy laws. So someone who is living in the same kind of apartment, in the same house, paying, say, 15% of the rent of what you are paying because you came later and a subsequent tenancy legislation applies to you. So this is the case, I've been told, in Spain, for example, it may happen, but also in Austria and other European countries. So marginally we also try to tackle problems related to estate agents, and one problem which has come up in so many provisional national reports now is black market phenomena. And with this I want to show you, very provisionally still, what we might do in the future, how we might tackle on a predominantly legal basis such phenomena. Yeah? Black market, we use our own, say, of course, homemade definition, unofficial or unofficial informal contracts which violate legal regulations and therefore remain in an extra legal unprotected sphere, which is typically to the detriment of the tenant. Generalities which we have found: black market contracts exist in a majority of European states, and they dramatically increase the private sector. They are normally, of course, not contemplated. In many cases, they are not contemplated in official statistics, but they do exist nevertheless, which means that the share of private contracts is much higher than many statistics would say. And also, black market contracts are generally associated with a lack of legal protection, as I said, of the tenant, and also of low-quality housing. So, black market contracts are a usual way to house poor and especially immigrants. And there are, in most cases, no binding obligations for the landlord. So then we have tried to establish a provisional distinction among the types of violated norms, because this changes the analysis a lot. The first black market situation is that in which there is a violation of tax law provisions or registration requirements, which exist in many, but not all, European states. So the landlord does not want a written contract, as he or she wants to keep the whole lease secret, and generally with the purpose of tax evasion. And in most countries, such violations are irrelevant for the binding force, in theory, in all, even for the binding force of the contract under private law. So in theory, the tenant would not need to worry about the landlord not paying the tax. But so this is the situation in Germany and Austria, for example, because then legal default rules of the civil code would apply to these tenancies, and they are balanced or even favorable to the tenant. But, as I said, difficulties arise in other states, such as Spain, I've been told, that the tenant who has nothing, no written evidence, needs to prove that he's a tenant and he doesn't only hold a short-term lease. And this risk may, of course, dissuade the tenant from taking legal action, among other risks, of course, among the risks of, say, immigrants being illiterate and wanting nothing to do with the legal system at all. So what are possibly solutions? A very drastic Italian solution is the following. A low default rent is set by the law, and this applies at the request of the tenant in case the landlord omits the registration. You imagine the tenant has stayed, say, 10 years without registration in a black market situation, and then he is able to claim back about 80% of the rent paid in these 10 years with interest. So this is lawful This is lawful. So this is a drastic consequence introduced, say, 2 years ago, I think, and we do not actually know whether it's actually effective in practice. Yeah, so it's an extremely drastic situation. Of course, strong incentive for the tenant to take care of the registration. Yeah, and Austria and Germany have I think, of course, a more balanced solution, which says that. Is there a problem? No problem. Oh, three. Okay. Okay. So in Austria, there's a rebuttable presumption in many other states. If you are sitting in an apartment and you are able to prove that you pay rents, and then an ordinary, fully effective contract applies to your situation, and so the landlord would need to show the contrary. So the second category would be the violation of public law provisions of habitability. This is the most difficult situation, which is difficult to be resolved because it presupposes some degree of involvement of the public authorities. So I will skip that now. And the third kind of violation is the violation of prohibitions of transferability of contracts or of subletting. And this may be shown in various cases. Say, our first test case was Austria, where you have strong intertemporal splits between different rent regimes. Old contracts which statutorily set low rents can be transferred even among relatives at the same conditions than the original tenant has, and old contracts have been transferred illegally against one-off payments under the table, because these old tenants, old contracts, which are with a very low rent, they have a value on the black market if you can transfer them. Obviously, how could you remedy that situation? You could, of course, introduce a duty to restitute these one-off payments, which is already existing, but there are, of course, problems of proof. But you could abolish the intertemporal splits, or you could abolish the transferability of contracts altogether. So maybe only one further case, which is Sweden, which is particularly interesting. And in Sweden, you have an egalitarian, highly regulated rent system, as you may know. So apartments, a majority of the apartments are rent controlled and allocated according to waiting lists by a public agency. And in cities, and particularly in Stockholm, these lists are very long, and the position of tenant is strong. There is no right of termination by the landlord, and so on. And the abuse which happens is that apartments for which long waiting lists exist are sublet, by the tenants who eventually receive them. They are sublet illegally, or even sold illegally. So the tenancy is sold, not the apartment, of course, at high prices. This has a high economic significance in Sweden, and with a bunch of adverse economic and social consequences. I don't have time to go into that now. So, what are possible consequences, possible solutions? That the situation is that in such illegal situation, of course, the agency may terminate the main contract, so the master lease, and then the landlord may rent out the dwelling again. And the solutions are not so easy to find, but what one could do is give the subtenant the right to enter into the main lease contract at the same conditions after the lawful termination of the contract, because this might create an incentive for the subtenant to act in the situation. But of course, it destroys the waiting list system, if you introduce such a remedy. So, okay, so as I'm running out of time, so I hope I have aroused some interest on your side for this project, and we hope to come up with even more exciting conclusions in future years. And I thank you for your attention.